Good afternoon. My name is Marcel Jude and welcome to the COVID Law Malaysian series. These videos are made due to the current lockdown. I made them at home so that I know there's nothing much interesting on TV. You have seen the same old reports about the COVID-19, so we need to get our minds into other things, and so I'm making this video series to give you legal knowledge. Usually at most times you wouldn't listen to law videos because they are quite dry and rather boring stuff, but because of the lockdown you have no choice but to watch and listen to me. So today we are going to look at the salient characteristics of the Federal Constitution, whereas yesterday we looked at the historical origins. The Malaysian Constitution, being written, has been declared to be the supreme law of the land. This means that the Constitution is the fundamental law of the land, and any law inconsistent therewith is void. Malaysia is a federation of 13 states. Consequently, there functions in the country a federal government and 13 state governments. Originally, when the Constitution of 1957 came into force, the country was designated as the Federation of Malaya, as it comprised only the 11 states in peninsular Malaya. Sabah, Sarawak and Singapore were not constituent units of the Federation of Malaya. When these states joined the Federation in 1963, it came to be designated as the Federation of Malaysia. Or should I paraphrase that? When these nations joined the Federation in 1963, it came to be designated as the Federation of Malaysia. The federal government functions under the Federal Constitution. Each state has a constitution of its own besides the Federal Constitution. Therefore, a state government functions under the Federal Constitution as well as under its own state constitution. The provisions set out in Part 1 of the 8th Schedule to the Federal Constitution are known as the essential provisions and are to form part of every state constitution. If a state constitution does not contain these essential provisions or contains provisions inconsistent with these essential provisions, Parliament has the power to enact a law to give effect in that state to the essential provisions or for removing the inconsistent provisions from the state constitution. The basic purpose of these provisions is to introduce a semblance of parliamentary system in the states and to transform the rulers or sultans into constitutional heads. Before 1957, the rulers were not constitutional rulers. In case of inconsistency between the federal constitution and a state constitution, the federal constitution prevails over the state constitution. Parliament may by law, number 1, admit other states to the federation, and number 2, alter the boundaries of any state. The Malaysian Constitution introduces a parliamentary form of government based on the British model. A notable feature of the Constitution is that it codifies a number of conventions which lie at the heart of the parliamentary system in the United Kingdom. Although the Constitution belongs to the family of the Federal Constitution, the federal government is by far in a stronger position than the state governments. This raises the question whether the system in Malaysia should be characterized as federal or quasi-federal or federal with centralized tendencies. We now turn to the judicial system. The Malaysian Constitution seeks to establish a hierarchical judicial system with the federal court at the apex. The Constitution seeks to preserve the independence of the judiciary to some extent. It lays down a special procedure for the removal of a judge of the High Court, the Court of Appeal, and the Federal Court. The most important task assigned to the judiciary is to protect the supremacy of the Constitution. It is therefore for the courts to interpret the Constitution and to assess the validity of any law or executive action vis-a-vis the Constitution. It is this function of the judiciary makes it absolutely essential that the independence of the judiciary be preserved. The courts appear to have interpreted the constitutional provisions narrowly and literally. It has been recognized that it would be improper to interpret one provision of the Constitution in isolation from the others, and that no conflict between the different parts of the Constitution were intended by its framers. Now we move to the status of the Constitution. The Constitution contains provisions intended for dealing with situations that may be termed emergencies. The emergency powers allowed to be exercised may appear to compromise the supremacy of the Constitution owing to the use of methods such as preventive detention. An order of preventive detention is made by the executive subjectively, and adequate safeguards would need to ensure against the misuse of power. The Constitution seeks to guarantee some basic rights to the people, such as the right to life, right to equality, and the freedom of speech. However, when an emergency proclamation is made, Parliament can legislate so as to meet the emergency, even if this means overriding the fundamental rights of the people, though not all may agree with this. The courts have also adopted a literalistic and narrow rather than a liberal interpretation of constitutional provisions guaranteeing these rights. The Constitution can be regarded as belonging to the family of rigid constitutions, as the process of constitutional amendment is more difficult than the ordinary legislative process. However, since its inauguration in 1957, the Constitution has undergone a large number of amendments, the trend being to enhance the power of the executive and to make emergency provisions more drastic than they were originally in the Constitution of 1957 and 1963. Also, through these amendments, more restrictions have been imposed on the fundamental rights of the people. Although by and large the Malaysian Constitution is based on modern constitutional ideas and notions, there are a few traditional values that have been incorporated into the Constitution. Firstly, Islam has been declared to be the religion of the Federation. However, that does not make Malaysia a theocratic state, as freedom to profess and practice their particular religion has been guaranteed to every person in the country, and any discrimination against any person on the ground of religion only has been outlawed. Secondly, the institution of hereditary rulership is not only preserved but protected by the Constitution. 9 states in the Peninsular Malaysia have hereditary rulers. The only significance between the pre- and post-constitutional position is that now a ruler acts as the constitutional head of the state, formerly used to exercise absolute powers of the state. The position has undergone a change. The Constitution now makes it clear that in an exercise of his functions, a ruler must act in accordance with the advice of the Executive Council or a member of it. The Executive Council in a state is the replica of the Council of the Ministers at the centre. One of the 9 rulers assumes the office of the Supreme Head of the Federation, known as the Yang di-Pertuan Agong, every 5 years. Thirdly, the institution of Conference of Rulers has not only been preserved but also assigned several significant functions under the Constitution. For example, the Yang di-Pertuan Agong is elected by the Conference of Rulers. The Conference of Rulers must be consulted in the matter of the appointment of the Chief Justice of the Federal Court, the President of the Court of Appeal, and the Chief Judges of the 2 High Courts and other judges of these courts. A constitutional amendment adversely affecting the status, position, privilege, sovereignty or prerogative of rulers cannot be made without the consent of the Conference of Rulers. Fourthly, the special importance has been given by the Constitution to the Bahasa Malaysia language. Fifthly, the Constitution seeks to preserve the special position of Malays and Bumiputras. That's the end of this part regarding the salient characteristics of the Federal Constitution. See you again. Bye.